Welcome to this explainer. Today we're diving straight into a truly dramatic day at the Constitutional Court of South Africa. The date was August 24, 2000, and we're going to use the events of that specific day to bust a massive, pervasive legal myth. You know, a lot of people, even seasoned legal professionals, operate under this assumption that if two opposing sides in a dispute just agree on something procedural, the judge will simply rubber stamp it. Well, as we're about to see through the lens of this fascinating case, making that assumption is incredibly risky.
Picture this scene for a second. Both parties have been talking leading up to the hearing date. They walk into the situation absolutely certain that their agreed-upon postponement is a done deal. In fact, they are so incredibly confident in this mutual agreement that the opposing lawyers don't even bother to show up to the court that morning. I mean, they figured, hey, the delay's guaranteed, right? Why even travel? Only for the Constitutional Court to completely blindside them by flatly refusing the delay. So instead of a quick rubber stamp, the appellant's newly instructed lawyer is just left standing alone in the courtroom, basically having to pack up his bags.
And this brilliantly illustrates the immediate consequence. The appeal was abruptly struck from the roll. Now, what does that actually mean in practice? It essentially means the case was kicked off the court's calendar for the day. The matter wasn't heard, and interestingly, the court made no order for costs. It was just a complete derailment. The newly hired counsel for the appellants was left entirely stranded, completely unable to proceed with arguing the case, and the whole day was an absolute wash.
So naturally, you gotta wonder, what on earth went wrong behind the scenes? How does a case make it all the way to the highest court in the land, only to fall apart on the morning of the hearing? To understand this shocking refusal by the judges, we need to peel back the curtain a bit and look at the utter lack of preparation, as well as the intense backstage drama involving the appellants and one of their attorneys, a firm called Dithal Incorporated.
The appellants came armed with a whole laundry list of excuses for being unprepared. They claimed they were embroiled in this massive, messy dispute with Dithal Incorporated. According to their side of the story, the relationship had completely broken down. They were dissatisfied with the firm's work, they were unhappy about the specific advocate that had been selected to argue for them, they claimed there was a serious lack of consultation between Dithal and their original attorneys, and of course, as is literally always the case in these breakdowns, there were bitter disputes over the fees being charged.
All of this conflict culminated in what we'll call the two-day excuse. The second appellant claimed that this massive disagreement reached an absolute boiling point, resulting in Dithal's instructions being formally withdrawn just 2 days before the hearing at the Constitutional Court. 2 days! Because of this incredibly late withdrawal, they claimed they had to scramble, hiring a new lawyer the very day before the hearing. And so they argued this newly hired lawyer had absolutely zero instructions or preparation time to proceed. But right here is the core legal principle we really need to grasp today. The Constitutional Court made it crystal clear that it has the inherent power to regulate its own process. This means a postponement is never a guaranteed right. Actually, scratch that. It's not a right at all. It's classified as an indulgence. And an indulgence is basically a favor or a privilege granted by the court. You cannot just walk into a courtroom and demand a delay as a matter of right, no matter how chaotic your backstage attorney drama might be.
To actually get that indulgence, to earn that favor from the judges, the applicant has to clear a pretty strict 3-step legal hurdle. First, they must show good cause for why the delay is even needed. Second, they have to furnish a full, completely satisfactory explanation of all the circumstances that led to the request. You can't just leave out the embarrassing details. And third, and this is arguably the most important one, they must satisfy what the court calls the interests of justice.
Now, what's really interesting is how the court actually defines the interests of justice. It's not just a buzzword. They weigh several specific factors, like, did you ask for the delay in a timely manner? Is your explanation full and satisfactory? Is anyone going to be unfairly prejudiced by having to wait? Is the other side fighting the delay? But the real key factor here is the public interest. The interests of justice aren't just about what the two specific parties in the lawsuit want. The court explicitly stated that they must consider the broader public. The public has a massive interest in having legal matters finalized efficiently, without the courts being clogged up by endless, undue delays caused by unprepared litigants.
Which brings us to a really pivotal question. If the other side literally didn't mind the delay, remember, they actually agreed to it and didn't even bother to show up, why did the Constitutional Court care enough to strike it from the roll? How did the appellants fail this test so spectacularly?
Well, the answer lies in the timeline. The court basically drove a truck through the plot holes in the appellant's story. Remember that 2-day excuse? Well, the judges looked at the record and pointed out that the attorney, DeHall, actually withdrew on August 2nd. The hearing was on August 24th. That means DeHall withdrew a full 3 weeks before the hearing, not 2 days. And the appellants provided absolutely zero explanation for what they were doing during those crucial 3 weeks. If they knew their attorney bailed on August 2nd, why on earth did they wait until August 23rd to hire someone new? This total lack of a satisfactory explanation completely destroyed their claim of good cause.
And honestly, the court didn't stop there. Further destroying the appellant's excuse was the simple fact that detailed heads of argument had already been filed by both parties well in advance. The written legal arguments were submitted, they were on the record, and they were already in the judge's hands. This meant the matter was actually completely ripe and ready for a hearing anyway. There was no real reason the case couldn't be argued right then and there, which further proved that the request for a delay was completely unjustified.
So, this all builds to the ultimate myth-busting moment of the entire explainer, perfectly captured in the ruling from Justice Malgaro, who delivered the judgment. She stated on the record, a postponement will not be granted simply because the parties agree to it. That is a powerful reminder to the entire legal profession. A judge's discretion and the court's strict schedule absolutely cannot be bypassed by a simple handshake or a quick phone call between opposing lawyers. Ultimately, the court is in charge of its own room.
Because of this, the court also handed down a really stern warning to everyone involved, particularly those lawyers who decided to just sleep in. They ruled that if you were asking for a delay on the actual day of the hearing, the opposing legal team still needs to show up, period. Even if they agree to the delay, they must be present to assist the court, just in case the application is denied. Because if the judge looks at you and says no to the delay, someone actually has to be there to deal with the immediate consequences and proceed with the case.
So, where does this actually leave our completely unprepared appellants? Well, as the court noted, the doors aren't permanently bolted shut on them just because the case was struck from the roll. But it does bring up a massive, lingering question about their future. They can apply to reinstate the appeal, sure, but they now face an incredibly heavy burden to get back into that courtroom. To successfully reinstate the appeal, they don't just have to go back and fully explain their previous failures leading up to August 24th, including, by the way, that highly mysterious 3-week gap. They also have to explain away any time that has lapsed since being struck from the roll. But here is the real kicker. They must now prove they have actual prospects of success in the underlying case. The court is not going to reopen the doors if the case is weak to begin with. It really leaves us to realize just how disastrous a simple lack of preparation can truly be. What seemed like a simple agreed-upon delay morphed into an absolute uphill battle for survival. It kind of makes you wonder, doesn't it? How many other guaranteed agreements in life are actually just waiting for a judge or reality to strike them from the roll? Think about that the next time you assume an extension is just a handshake away.